Virginia has a moderately regulated tenant screening environment that has become more restrictive in recent years, as the state legislature has enacted several tenant protective measures. The governing framework includes the Virginia Residential Landlord and Tenant Act, found in Virginia Code Title 55.1, Chapter 12, along with FCRA and the Virginia Fair Housing Law. If you're screening tenants in Virginia, you need to understand both the long-standing requirements and the newer provisions that have changed the landscape. Let's start with application fees. Virginia has a specific statutory provision governing screening fees under Section 55.1-1203. Landlords can charge an application fee, but the fee cannot exceed $50. This cap applies per applicant. If two adults are applying for the same unit, the landlord can charge each of them up to $50. The $50 cap is adjusted periodically, so landlords should verify the current limit. The landlord must use the application fee solely for the purpose of screening the applicant, including obtaining a credit report, criminal background check, and verifying references. If the landlord doesn't actually use the fee for screening purposes, the fee must be refunded. Virginia also requires that the landlord provide the applicant with a written statement of the tenant selection criteria before collecting the fee, so applicants know what standards they'll be evaluated against before paying. This upfront disclosure requirement is important. Your written criteria should include your credit score threshold, income-to-rent ratio, rental history requirements, criminal history evaluation standards, and any other factors you consider. Having this documented and ready to share is a legal requirement, not a best practice recommendation. Criminal history screening in Virginia has undergone significant changes. While Virginia does not have a comprehensive statewide ban-the-box law for housing, the legal environment has shifted in ways that affect how landlords use criminal records. Virginia law does not prohibit landlords from asking about criminal history on the initial application. Landlords can inquire about convictions and can consider criminal history as part of the screening process. However, several important limitations apply. Virginia expanded its expungement and sealing laws in recent years, and landlords cannot consider records that have been expunged or sealed under Virginia law. Virginia also decriminalized simple marijuana possession, and landlords should be cautious about using marijuana possession records, particularly older ones, as a basis for denial, since the underlying conduct is no longer criminal in Virginia. The most significant local criminal history restriction in Virginia comes from several Northern Virginia jurisdictions. Arlington County, Fairfax County, and the City of Alexandria have been at the forefront of tenant protective measures in the state. While comprehensive ban-the-box housing ordinances have been debated, landlords in Northern Virginia should monitor local developments carefully. The political environment in these jurisdictions favors additional screening restrictions. Richmond has also been active in discussing fair chance housing measures. Landlords operating in Richmond should stay current on any local ordinances that may affect criminal history screening. And as with every state, HUD's 2016 guidance on criminal history and disparate impact applies. Blanket policies that reject all applicants with any criminal record can violate the Fair Housing Act if they disproportionately affect protected classes without legitimate business justification. Virginia landlords should use criminal history criteria that consider the nature of the offense, how long ago it occurred, and the relationship to the tenancy, rather than applying an automatic rejection policy. Source of income protection in Virginia was enacted in 2020 and represents one of the most significant recent changes to the state's screening landscape. Under Section 55.1-1310, landlords who own more than 4 rental units cannot discriminate against applicants based on their lawful source of income, including housing choice vouchers, government subsidies, Social Security, disability payments, and other forms of assistance. This is a major change. Before 2020, Virginia landlords could freely decline voucher holders. Now, landlords with 5 or more units must accept voucher-paying applicants on the same basis as market-rate applicants, evaluating them based on their overall ability to pay rather than rejecting them based on the source of their income. The income must be sufficient when considering the voucher payment plus the tenant's portion, but the landlord cannot reject the applicant simply because a portion of the rent comes from a government subsidy. There is an exemption for landlords who own 4 or fewer rental dwelling units. These smaller landlords are not subject to the source of income protection. However, they remain subject to all other fair housing requirements. Virginia's source of income protection is enforced by the Virginia Fair Housing Office and through private causes of action. Violations can result in damages, attorney's fees, and injunctive relief. For credit reports, Virginia follows FCRA requirements for permissible purpose and written consent. Virginia does not impose additional state-level requirements for accessing credit reports beyond the federal baseline. However, the adverse action process should be thorough. Virginia's legal environment favors detailed documentation of denial reasons. Virginia requires landlords to notify applicants of the screening decision within 7 days of receiving the completed application or within 7 days of the application being treated as complete, whichever occurs first. Under Section 55.1(1203), if the landlord denies the application, the landlord must provide written notice to the applicant identifying the basis for the denial. This timeline and notification requirement go beyond what FCRA alone requires and ensure that applicants receive a prompt response. If the landlord accepts a conditional applicant over other applicants, the landlord must refund the application fee to the denied applicants if screening was not actually conducted. This prevents landlords from collecting fees from multiple applicants when the unit is already committed. Virginia's fair housing protections under the Virginia Fair Housing Law, found in Virginia Code Section 36-96.1 and following, prohibit discrimination based on race, color, religion, national origin, sex, elderliness, familial status, disability, sexual orientation, gender identity, military status, and source of income for landlords with 5 or more units. Virginia's inclusion of sexual orientation, gender identity, and military status as protected categories goes beyond the federal baseline and reflects the state's evolving fair housing framework. The Virginia Fair Housing Office investigates complaints and can take enforcement action. Virginia also has a specific provision protecting victims of domestic violence, sexual assault, and stalking in the screening context. Landlords cannot deny an application based on the applicant being a victim of domestic violence, or based on incidents related to domestic violence at a prior address, including police calls, property damage caused by the abuser, or lease violations attributable to the abuser's conduct rather than the victim's. From a practical standpoint, Virginia's rental market is one of the strongest in the Mid-Atlantic region, with dramatic variation between Northern Virginia, the Hampton Roads area, Richmond, and the rest of the state. Northern Virginia, including Arlington, Alexandria, Fairfax, Loudoun County, and Prince William County, has one of the most expensive and competitive rental markets in the country. The market is driven by the federal government, defense contractors, technology companies, including the Amazon HQ2 in Arlington, consulting firms, and the massive professional services sector that supports the federal government. Rents are extremely high, demand is strong, and the applicant pool is generally well qualified. Northern Virginia's political environment is also the most tenant protective in the state, and landlords should anticipate that local regulations may become more restrictive over time. Hampton Roads, including Norfolk, Virginia Beach, Newport News, Hampton, Chesapeake, and Suffolk, has a strong rental market driven by the massive military presence. Naval Station Norfolk is the largest naval installation in the world. Langley Air Force Base, Fort Eustis, and the Newport News Shipyard all generate enormous rental demand. Military tenants represent a huge portion of the Hampton Roads rental market, and landlords should understand military income documentation, leave and earning statements, BAH rates, and the Service Members Civil Relief Act. BAH rates for the Norfolk, Virginia beach area are substantial and drive pricing for a significant segment of the market. Richmond, the state capital, has a growing rental market driven by state government, healthcare, including VCU health system, financial services, and a revitalizing urban core. Richmond's Scott's Addition, the Fan District, Churchill, and Manchester neighborhoods have seen strong rental demand and rising rents. The city has been active in discussing additional tenant protections, and landlords should monitor local developments. Charlottesville, home to the University of Virginia, has a tight market driven by the university and healthcare. Blacksburg and Radford, home to Virginia Tech and Radford University, have student-driven markets. Lynchburg, home to Liberty University, has a market influenced by the university's massive enrollment. One best practice for Virginia landlords: provide your written screening criteria to every applicant before collecting the application fee. This is a legal requirement under Virginia law, and failing to comply can result in having to refund the fee. Your criteria document should be professional, specific, and applied consistently to every applicant. Another best practice: if you own 5 or more units, make sure your entire screening process is compliant with Virginia's source of income protection. Remove any language from your listings, applications, or policies that says you don't accept vouchers or government assistance. Train anyone who handles inquiries or showings to never state that vouchers aren't accepted. Even a casual comment from a leasing agent can form the basis of a discrimination complaint. Virginia requires landlords to return the security deposit within 45 days of the tenant vacating. The deposit is limited to 2 months' rent. While these rules don't directly govern screening, the deposit limit makes thorough screening critical. Your financial cushion against problem tenants is capped at 2 months. For the complete guide to Virginia tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.